Hi, I'm Christina Blacklaws, and I've been helping people understand family law for over 20 years, so I know it can sometimes seem confusing. If you're considering ending a marriage or a civil partnership, it's important to remember that you're not alone. At a difficult time, the last thing you need is to be confronted by strange legal terms and definitions. You may be aware that if you're having relationship problems, there are many good services available to offer couple counselling if you're unsure whether you want to legally end the marriage or civil partnership now. I want to clarify some of the key issues you might face during the divorce process and explain where you can go to receive good, trustworthy legal advice without it costing the earth. Perhaps the best place to start is to highlight the difference between ending a marriage and ending a civil partnership. The legal process for ending a marriage is called divorce. Divorce is not the only option, though, if you're facing the breakdown of a marriage. Some couples prefer to go for something known as a judicial separation. This is an order which confirms you will legally live apart, but you remain married. We have a separate video in which we explain the meaning and process of a judicial separation. Whatever you decide to do, a lot of people find using an impartial mediation service is also an effective way of reaching an agreement. The legal process for ending a civil partnership is called dissolution. Some couples prefer to go for something known as a legal separation. This is an order which confirms you'll legally live apart, but you remain in your civil partnership. We have a separate video in which we explain the meaning and process of a legal separation. With both, you have to have been together for over a year before you can start the process of seeking a divorce or a dissolution. And for either a divorce or dissolution to be accepted, you have to be able to prove your relationship has, in legal terms, irretrievably broken down. This means that the relationship has reached a point where you can't reconcile your differences or continue to live together. In practice, this means you need to be able to show one of the following facts has taken place: unreasonable behaviour, desertion, separation after 5 years, separation after 2 years and consent, adultery. It's worth noting that with civil partnerships, adultery can't be relied upon for a dissolution. The legal process itself actually begins with the issue of something called a petition. This is a document submitted to the court containing all the facts and information about why one of the parties wants to end the relationship. If you have children, you'll also need to complete a statement of arrangements. This outlines how you plan to manage the lives of your children. The petition also names both parties in the relationship. The one initiating the divorce or dissolution is known as the petitioner, and the one actually receiving the documents is known as the respondent. As the petitioner, it's your responsibility to make sure the other party has been given copies of all the appropriate petition documentation. As the respondent, you have the option to either agree or contest the petition. Once you've made up your mind, the next step is to respond to the petition, confirming that you've received it and indicating whether you wish to defend it or not. It's possible for the respondent to defend a petition to try and prevent a divorce or dissolution taking place. However, it's extremely rare for a respondent to do so. Less than 1% of cases are defended, and of those that do, the majority will fail. Quite simply, if one person insists the relationship is irretrievably broken down, it's usually possible to convince a judge of this. If it does go ahead, a divorce or dissolution should normally follow 3 distinct stages: the start of the process and formal submission of the petition, the issue of something called a decree nisi or conditional order. This is a document issued by the court saying it's satisfied there are sufficient grounds for divorce or dissolution. This order is made at very short hearing, which is usually in the absence of anyone attending, unless there's an argument about who should pay the costs of the case. The final stage is the issue of another document called a decree absolute or final order, marking the official legal end of the relationship. A straightforward divorce or dissolution can take between 4 and 6 months. By straightforward, we mean one in which both parties are relatively agreed about the breakdown of the relationship and cooperate with the procedure. In some cases, it can take longer if there are any disagreements about the process or if there is a need to make arrangements for children or financial issues. You can find more specific information on each of these areas in our other videos. No one wants to experience a divorce or dissolution, but if it's something you are having to deal with, I hope this short introduction has helped clarify the procedure.